Good evening. This is Laws 11057, Introduction to Law. It's Term 3 of 2014-2015, and tonight we're dealing with weeks 8 and 9. I want to start with some preliminary comments in relation to the exam. In the exam, you can expect it very likely that there'll be some request that you consider the separation of powers. Given that I've emphasised the separation of powers throughout the course, that won't come as any great surprise. I think I've already announced to you that there will be a question involving the redrafting of legal gobbledygook. And you can expect there'll be some questioning in relation to the following topics, such as ethical obligations, particularly that of an advocate. You might expect some questions in relation to the difference between legislation and common law. And then some questions in relation to the difference between common law and equity. I've mentioned judicial activism and the Mabo decision, which is the prime example, to my mind, on several occasions, so you might expect some questions about that. I probably need to stress this more, and I propose to do some part of this tonight. And that is talking about the process of taking instructions from a client and preparing. You might expect that. I like to think that you'll be broadening your legal horizons to think about brainstorming what may be possible solutions to a particular problem. So that's all part of the process of taking instructions and preparing. You might want to consider the process of taking instructions from a client with a view to appearing as an advocate. We talked briefly about that, I think, the week before last. Some other things that I want you to be aware of that may be examinable relate to self-management skills, and that is maintaining proper equilibrium. It is stressful being a lawyer, it's stressful practicing in law, and you need to develop some mechanisms to deal with that. So unashamedly, I may ask you for some practical information about how you propose to deal with that. We're dealing with legal research skills. We've had some great contributions already from students, and you might expect a question about your ability to research legal matters. You might expect, as a possibility, a question relating to legal thinking and being a critical legal thinker. And finally, how you might be an effective communicator, verbally and in written form. Some practical issues may arise in relation to those things. So there are a range of questions from which the examination questions might be drawn. It's not an exclusive list. It's not to say that every one of those will be on the exam, and it's not to say that others, which I haven't mentioned, won't be on the exam. They may be. So it just gives you some guide. And having gone through that list, if you believe that there are areas that we need to emphasise in greater detail during these sessions or through Moodle or UCrew, please let me know, and I'm happy to expand on that. Speaking of providing feedback, this is what I call Feedback Week. It's your opportunity to discuss any problems that you're encountering, things that you might wish to discuss in terms of assessments, whether that's assessment number 3 or the examination itself. If there are concerns that you have, if there are any questions that you have, please ask them, either through the Zoom session or UCrew or Moodle. Because if you've got some questions or if you've got some concerns, then there's a very good chance that your fellow students may have as well. So there's no such thing as a silly question. We're all here to help and support each other, so I do encourage you to ask any questions or make any comments about problems that you're encountering, and we'll try and help. So I'm very keen also for you to tell me what you think about this course. You may have noticed on Moodle that the feedback icon has now appeared in the top left-hand corner. And I do encourage you to provide feedback which is very important for the university, and it's important for me as well. And obviously that feedback can be positive or negative. It's all confidential. So I do ask you that you please look at that and please participate in that program. I must confess that at times, as I mentioned on the program, I had expected some greater participation from some people in the course. The great majority are participating well, but I'd like to see everyone participating. So if you feel that you haven't participated to the degree that I might expect you to, then please feel free to start participating and do so as vigorously and as keenly as you like. It's all about communication and it's all about learning together. So I encourage you to do that. Now, I do want to talk to you about the presentation of materials, both in the assignments and the exam, and also with a view to giving you some guidance as to how you might go about dealing with legal studies into the future. The first point is this. If you haven't looked at my sample document, then I urge you to do so straight away. Those of you participating in the Zoom session are probably people that have looked at that straight away. So in that sense, for those of you participating live, I may be preaching to the converted. But I must confess that it's clear to me through the assignments that I've received that not all of you have looked at it, and I urge you to do so. There are some basic things. Please put a page number to each page of your paper. I call it paginate. So put a page number. I would recommend that you use double space between sentences. You don't have to do that, but I think the way in which the document looks does help in terms of conveying the information that you wish to convey. Many of you are very good now at simply typing legislation and cases in italics. That's the way it's done in the law books, that's the way it's done in the cases, and that's the way you should do it. Make sure that you properly refer to cases using the appropriate citation, and we don't use the hyperlink email address when we're referring to case law in written legal material. We use the case citation. There are some little things when you're referring to the word act in the context of legislation, capitalize that word. So it's capital A, CT. Not the whole lot, just the capital A. Take care with your grammar. Look, here's a really simple thing. I have asked that you submit your documents in Word. My apologies to those of you who are using Google Docs or Apple Docs. But in Word, at least, there's a very simple way of identifying if there's a problem with grammar. Just look to the yellow or the red underlining for spelling or grammatical errors, and that will give you a hint that something might need to be changed. So if you present an assignment to me and it's full of red and green underlining, I'm sorry, I can't help but look, and it just makes it so easy for me to pick up on issues that should not be disclosed. I've mentioned to you that I really do want everyone who passes through this course to present themselves in a very professional way in terms of their verbal and their written communication. And that's a really simple way of checklisting to ensure that everything is fine. You know, if you don't want the green underlining or the red underlining, there's a very simple way to get rid of it. You just right-click and you can delete the underlining. But the main thing is that if you fix it, the underlining will go away. Now, I'll just take a break there. Does anyone have any questions or comments about what I've said in terms of presentation? Does anyone have any tips that I haven't mentioned so far in terms of the way in which they present their material? And you don't have to agree with me. I welcome disagreement. No comments? You can use the chat facility too. All right, while you're thinking about that, I'll continue. Be innovative. Use flowcharts, for example. There are some terrific, easy ways to incorporate interesting material into your assignment work. And don't be afraid to do that. If it's good enough for the textbooks, then it's good enough for assignments in my view. Sometimes you'll need to provide the assessment in a very formal way, as if you were writing a court judgment, but generally not. Make sure you use footnotes now. I haven't been insisting on it, but I really do want you to start using footnotes properly. And if you're not if you're not using the footnotes which is referred to in the Word document, then I urge you to do so. Now, Vicky's made a comment that she does like lists and dot points, and I've got to say I equivocate on that point. Sometimes I think there are great circumstances when you can use lists and numbers, and other times where I don't. I suppose the negative comments that I've made about using lists is that, at least to my mind, I tend to gloss over them, and that's why I sometimes discourage the use of them. But they're a very popular way of communicating, a very efficient way of communicating, and if you do it well, or you write your commentary well, then you're not going to be penalised for it. But I think just be careful to ensure that it's not easily glossed over, is probably all I'll say about that.
John?
Yes?
With the dot points, there used to be a rule with PowerPoint presentations. I think it was something along the lines of 5 words across and 7 points down, or 8 points down. And I think that probably very much applies to dot points as well, because the idea was you don't make it too long and you don't have too many.
I think that's a great tip. Thank you very much, Peter. How do you feel about that comment, Vicky? We've lost Vicky. Thanks, Vicky. Are there any other comments? Oh, thanks, Vicky.
I agree with Peter. I do like the way you can fit a lot of information into some dot points.
Okay.
Yes, so I agree with Peter in that, you know, you've got to minimise the amount of dot points, the amount of information you put in there in the 1 point.
All right, thank you. It was breaking up a bit there, Vicky, but I think we picked up on the gist of that. So thank you very much for that contribution. Are there any other comments that people wish to make? Do you think, for example, that I'm being a little silly in emphasising the way in which the material looks? And if it's not apparent to you, the reason that I do that is that you've got to get your foot in the door. And if the document doesn't look well presented, professionally presented, then it will be to some degree dismissed by the reader, whether that's me or someone else. So present it well, present it professionally, make sure it's consistent in the way in which it's presented, and immediately you'll have your potential reader liking your work. Not saying you won't necessarily get top marks or full marks, but you're a chance. So it's important, I think. Okay. Let's move on to legal research. I mentioned, I think off camera, that I run the risk of annoying you now by referring you to something which I don't believe, previously referred you to. I think it is important that I get you to read chapters 6 and 7 of The New Lawyer. You may well have read that already. Chapters 6 and 7 deal with legal research. The basic skills of legal research are referred to on page 192 of the text and can be summarised in terms of being systematic in your approach, knowing where to look, having good quality information, and your ability to read actively and effectively and apply your research. Now let's just talk about some of those things. Adopting a systematic approach is probably something which comes with a bit of practice. And there's not necessarily going to be a correct systematic approach or an incorrect approach. Sometimes people will vary in their approach depending on their personal preference in that regard. Let's take an example. A client comes into you and says, look, I've been appointed the executor of an estate. The person passed away some 5 years ago. In the will, it provided that I'm under an obligation to pay one of the beneficiaries a certain sum of money when he or she turns 21. The reason I've come to see you today is that that person is about to be 21. I have invested the amount of money which was earmarked for that beneficiary. Should I provide the beneficiary with the amount of money which was provided for in the will, or should I also provide them with the interest which has accrued on that? So we have a legal problem. One would think that that's probably easily solved. But tell me, using a systematic approach, how would you go about researching that and providing the appropriate and correct answer? Does anyone wish to make any comments or suggestions? You can do so using the chat facility, or you can come in live and make a comment. We've got a problem with a will. We've got a client who just wants to do the right thing in administering the will. I'm not really interested in the answer. I'm interested in your thoughts as to how you would adopt a systematic approach to finding out the correct answer. Where would you look? Now, let's fire away. Any suggestions? Where would you look to find that answer in relation to the problem associated with administration of an estate? We've got nothing on the chat facility yet.
Is there an estate law?
What was that? Sorry, Maria?
Is there an estate law that applies to that?
Find the state law. Yes?
Estate law?
Okay, estate law.
Yes.
Okay. So where would you look? Josh says you'd look at the Trust Act. Where would you look to find this estate law? Josh says the Trust Act. Is that state or federal, Josh? State, correct. It's actually, I would look more at the Trust Act might be correct. I'd probably look at the Succession Act first up. But there's a very basic issue, and that is, do you look to the primary source or do you look to a secondary source? Now, when it comes to legal research, you have to make that basic distinction. Firstly, what is a primary source and what is a secondary source? Vicky says she'd go primary. I would go primary. But what is primary? What is secondary? Any comments? Vicky says primary is law and cases, so legislation and case law, correct. I agree with that. Does anyone disagree? So what's secondary? What's a secondary source? No comments coming in yet. Databases, yes, I agree with that, Vicky. Josh says comments and notes. I agree with that. Thank you. Textbooks, secondary. Okay, so the primary source of the law is the legislation and the case law. The secondary source is what people, commentators, have said about that. I like to go primary first, but that's all part of a systematic approach. It's important that you understand where to find some of the really important things. Remember early on I gave you that exercise of finding the Australian Consumer Law and the Criminal Code of Queensland. One was federal, one was state. The federal one applied at a state level through legislation. But they're really important key areas where you've got to find out information. So just be mindful of that you're going to be asked a whole range of different questions, and you're not expected to know the answer, but you are expected to know how you might start finding the answer. Clint says Succession Act 1981, spot on, Clint. That's exactly where I would go for that problem. All right. Reading actively and efficiently. We talked about that a few weeks ago. Do you remember I gave some hints on how to speed read and how to read textbooks. You're going to need to apply that not only for this subject, but for future subjects as well. Okay, the next thing I want to talk about is planning your research. You need to identify the task, and that is, are we drafting a contract? Are we preparing a deed? Are we preparing an opinion? Are we preparing some pleadings? So you need to know what the task is ultimately that you have to do. You need to identify the specific area or areas of law, and this can be difficult. So in the case example I gave you, that was fairly easy in that we were talking about estate law, as Maria said, the administration of an estate. That was pretty straightforward. But sometimes it can be difficult. And sometimes you need to consider aspects of contract law, torts law, which is dealing with things like negligence and nuisance, the Australian consumer law, the statutory provisions, criminal code, etc. And what that means is, and this is really important, I think, that you need to be prepared to brainstorm. You need to keep an open mind when it comes to legal research or the way in which a legal problem can be resolved, and you need to think about lots of different options and be prepared to adopt a scattergun approach at the start so that you can identify as many potential areas which might be relevant to a particular case. So let's do a little brainstorming exercise right now. You have a client who comes to you and says, I've lost some money in an investment scheme. What can I do about that? So, using the chat facility or coming in live, tell me what options are available. A client says, I've lost money in an investment scheme. What do we do about it? What can we do? Let's fire away and get some ideas. Peter says, were the conditions of the contract? So we look at the contract. And that's a very good idea. So we're bringing in contract law. The question then is, who's the contract with? And that's not necessarily an easy thing to do. So we need to identify the contract, correct? And we need to identify who are we contracting with. Were we dealing with a bank, for example, or were we dealing with an individual in a bank, or do we sue both of them? What was the money invested in? Well, let's assume it was some sort of share trust or property trust. So we need to see where the money was invested, and we need to identify who parked the money in the failed scheme. So it might be that it's not just the advisor that the person was dealing with, but also the fund manager, perhaps higher up the scheme. It might be a trust fund. We may need to consider whether the trustee of that fund was somehow responsible. Okay, so we've dealt with contract and we've dealt with who we might sue. There's more options available than that. Which country? Very good, Vicky. So are we dealing with Australian law or overseas law? Are we dealing with Queensland law, New South Wales law, Victorian law? That's relevant too. I'm not looking for any answers. I'm looking for issues that should be at least considered. Was there an insurance policy in place, says Josh? And was there an exclusion clause in the contract? So yes, as part of the brainstorming activity, we're thinking about things that might go wrong as far as the exclusion clause is concerned, but we're also thinking about lateral ways to resolve the issue. Hey, was there an insurance policy in place? Can we rely upon that? Maybe we don't have to litigate. Clint says, well, is there a regulatory body that we need to consider? And maybe there is. Maybe we can go to that regulatory body and seek assistance without necessarily having to sue and take the risks associated with it. Peter says, why are we just talking about contract? Maybe we need to broaden our horizons and think about negligence, or maybe it's even criminal. So we're talking about different branches of the law. There Maybe Vicky says we need to investigate, we need to do some investigations. Maybe issues like this have arisen before with this particular investment company. So part of our brainstorming might be, do we need to engage a private investigator to undertake some investigations? Or maybe we do that ourselves as well. Do we just Google, find out what's happened with this company before? Maria says, well, maybe there's some fraud involved, and fraud can be civil and it can be criminal. Clint says, well, before we get too excited about this, can we make sure that this isn't going to cost more than any benefit that we get? And that's a perfectly valid thing to consider about. Can the client afford to sue? Should the client afford to, should the client sue? So by brainstorming, we've raised a whole lot of different issues that may or may not be relevant. So thank you for that. Peter says, well, thank you, Sharon. What about the industry ombudsman? So that's an important thing as well. So you can expect there's a chance that in the exam, I will ask you for some sort of brainstorming activity. I may not necessarily be looking for the answer, but I'm looking for you to think laterally, to think creatively in resolving the issue. No one mentioned anything about alternative dispute resolution, mediation, arbitration, conciliation, so they're options as well. So let's think about that. Let's maybe do some work on UCRU and through Moodle this week to think about brainstorming activities. But always we need to consider the time frame, the cost, and the consequence. In terms of consequence, I don't think anyone mentioned the risk associated with suing, that if you do sue and you come second, you may have to pay the other side's costs. Or if you do sue and you win the gold medal, it may not be worth anything if the company that you've just sued goes into liquidation. And the client is entitled to know about these risks. And I think you all know what I mean when I say we came second in the litigation. It's another way of saying we lost. Lawyers don't like saying we lost. Coming second, a close second, sounds much better, don't you think? All right. You need to broaden your reading. You need to make sure that you expand your reading wide enough to ensure that you've considered all options that might be available to you. In the past, we've had some really good comments in terms of, I think, Boolean connectors. So if you're doing some research in LexisNexis, I think Michael covered this. You might put in director's duties and, capitalise and, duty of care, just as an example. So we've talked about primary, which is legislation and cases, and secondary, which is commentaries. So find some important pieces of reference material. Find some really important places that you might start to consider. First up, the Australian Consumer Law and the Criminal Code. Be careful about not spending enormous amounts of time in wasted research time. So you need to have this ability to be thorough and careful, but also speedy. Sometimes you need to skim or speed read first up, identify the areas that you think are particularly important and worthy of further commentary, and then come back and peruse in more detail through a second reading. Lawyers talk about scanning documents, which is that preliminary quick material, as opposed to perusal, which is the detailed reading. So on a lawyer's bill, you might see a certain amount of money associated with the process of scanning as opposed to the process of perusal. Once you've done your broad reading, you might then think about doing some detailed reading where you might read and indeed you might reread. And when you're getting down to that very careful detail, look out for special words such as unless, or and, or may, or shall. Some special words can change the context of what you're reading. So to come back to that first example of a client who wants some information about their duty as an executor of a will, once you've done your broad thinking and you've identified that, in your view, the answer to the question can be found in the Queensland Succession Act. Thank you, Clint. You might then read the particular section of the Succession Act 3 or 4 times to make sure that you fully understand it and you've picked up on any little words that can change the effect. That's where you don't want to be skim reading or speed reading. You want to be perusing in the true sense of the word. So that's the detailed section. All right, so are there any questions about legal research so far? No questions online, no questions through the chat facility. All right, well, I'll continue. So I'll just to recap, in my notes, under the heading of legal research, I've got number 1, basic skills. Number 2, planning your research. That included the brainstorming. Number 3 is that process of broadly reading. And number 4 is that process of detailed reading. And that's where I'm up to now. Number 5 is our old friend, the IRAC method. Who wants to remind me of what IRAC is all about? Anyone wish to come in? IRAC, I-R-A-C, what's all that about? You don't want me to do a Ferris Bueller here, do you? Anyone? Anyone?
It's about the issue, rule, explanation of the rule, and application of the conclusion.
Very good. Yes, so thank you very much for that, Jennifer. So it's identifying the legal issue, determining the appropriate rule or rules, applying the rule, and then stating the conclusion. Thank you very much. One thing you might consider as a preliminary to that is determining the relevant facts. And remember, we had that exercise a few weeks ago where we had to identify what was relevant in the context of someone who was doing some shopping. That's what I mean by some of the facts are relevant, some of them are irrelevant, and we don't need to waste any time on that. All right. And it looks like we're leaving. Yep, Maria's leaving. So citing the research, that's important. You'll need to be aware of the Australian Guide to Legal Citation. And I'm sure many of you have seen that. And we're now at the stage where I do want you to start citing your research appropriately. In legal writing, we don't cite in the body of the text as we do in the Harvard citation. We do so by the use of footnotes. We've talked about when we use italics and when we don't. In terms of referring to cases, have a look at page 222 of the text, and you'll see that where there is a volume, we use round brackets, and where it's simply a reference by way of year, we use the square brackets. So you would have seen that already. Sometimes there are cases are referred to with round brackets and sometimes square brackets. You'll need to know when to do that. The volume goes in if applicable, and the page. Sometimes you can pinpoint the particular reference in your material by referring to a paragraph or a page. All right, now there's an example. There are examples in the New Lawyer at pages 256 and 257. Do have a look at that. For example, Dietrich against R, open round brackets, 1992, close brackets, 177 CLR 292, 299. What does that mean? Well, we've gone the round brackets because there's a volume, and the volume there is 177. And the page number where the case starts is 292. But in this instance, we've pinpointed page 299 as the page that we're referring to. So there are a few things, a few different ways of doing it, but have a look at the Australian Guide to Legal Citation. But most importantly, just keep your eyes open when you're reading material, whether it's a case or a legal text, because odds are that it's going to be correct, and that's what you should follow. All right, so that's chapter 6. Chapter 7 deals with interpretation skills. So far I've got 6 headings that I've covered. Just to recap, number 1, basic skills. Number 2, planning your research. Number 3, broad reading. Number 4, detailed reading. Number 5, IRAC. Number 6, citing your research. And that's all from chapter 6 of The New Lawyer. Chapter 7, interpretation skills. Right, point number 7, interpretation of legislation or case law, which is precedents, and other documents. So there's some commentary in that regard. Number 8, drafting. Seek clarification at first instance as to what it is that you need to draft. So be clear about what you need to do, and have a look at some bad examples of drafting in The New Lawyer at page 237. You'll get that in the exam. I suppose one of the little jobs that I do quite enjoy is the nonsense. When I come to write one of those gobbledygook questions, you'll see some of those in past exams. And I think I'll ask you to rewrite something which I've taken about 400 words to say down to about 100 words maximum. Right, point number 9 is statutory interpretation. You'll all be doing, I suspect all of you will be doing a subject on this with Wayne Jones, but you'll be aware there's the literal approach, there's the golden rule, the contextual approach, the mischief rule, and I won't go through that other than by mentioning them. But note the common law presumptions, which are at page 250 of the text. Always, when considering legislation, I want you to do 2 things. The first is consider if there is a definition section in the Act itself, because by reference to the definition of a particular word or a phrase in the Act, that may well have a significant bearing on the way in which the section that you're looking at should be interpreted. So, for example, in the Transport Operation Road Use Management Act, there would be, I'm sure, a definition section. And in that definition section, there may be a definition of what is meant by road. And road in that Act may be defined as meaning a road in the sense that we think about it, but also may include private property. So if, for example, you're consulted by a client who says, look, I've been picked up for drink driving when I was driving my car down my private driveway, before you're quick to say, well, that's not an offence and you're not guilty and we'll run it to trial, have a look to see if road is defined in the Act. And it may come up with some interesting and perhaps unusual answers that you wouldn't have otherwise expected. Also, have a look at something like may, M-A-Y, versus shall. And that can have a difference. One is permissive and the other is prescriptive. All right. I appreciate I'm moving fairly quickly, but this is intended to be a guide to your reading to chapters 6 and 7. Number 10, and this is the final thing that I'll talk about in terms of chapter 7 of The New Lawyer, that is contractual interpretation. I'd like you to draw your attention to what we call the parole evidence rule. That is essentially the rule, and you'll learn about this in contract, but it's essentially the rule that says, look, if the parties have gone to the trouble of reducing their agreement to writing, then the courts will assume that everything which is important in the agreement between the parties will be found in that document. So that's what we call the parole evidence rule. Have a look at the list on page 260. Courts will imply a term, but only if the term is, and this has to be all of these, reasonable and fair, necessary, goes without saying, can be expressed clearly, and is consistent with the expressed terms. So, for example, you might be consulted by, let's say, a builder who is being sued for failure to comply with the terms of a building contract which required the work to be constructed by, let's say, the 31st of December 2014, the builder might say, well, I couldn't do anything because we had a cyclone. Now, you might argue on behalf of the builder that there was an implied term that the work would be completed by that date, provided there was no cyclone. So the argument to the court would be, yes, we had a written contract. We appreciate the parole evidence rule means that everything that was important should be included in that contract, but it's fair and reasonable to say that if there was a cyclone, there should be an extension of time. And that goes without saying. So that's the sort of thing that I'm asking you to consider in that commentary. And be aware, finally, of the difference between the objective and the subjective. In my sample document, I think I made reference to the man or the gentleman on the Clapham omnibus. You'll probably read about that sort of stuff down the track. But the objective versus the subjective simply means this. If an act says that something is the law or the legal position in a particular case, and your client says, well, I thought something in that context, you need to make the basic decision at law. Does your client's thought matter, or is the thought of someone looking at it objectively, is that the important thing? So the subjective is what your client thinks or what you might think. The objective is what a reasonable person looking on might think. And you need to make that basic distinction between the objective and the subjective. Gosh, I'm dealing with some tough stuff tonight. I'm sorry. Are you coping? Are you hanging in there with me? Are there any questions? I'll try to make it easier now. That's all that I wanted to discuss in terms of the New Lawyers, chapters 6 and 7. All right, no questions, nothing on the chat line. Objective versus subjective again. Yes, that's fine, Becky. I'll try to do a better job this time. Let's take this situation, and as soon as we finish this, I'll come up with some better examples, and I may even put them on UCrew in that regard. But if a contract said that compliance of a certain condition must be within a reasonable time, that's all very well, but how do we determine what's reasonable? Now, you might say that 10 is reasonable. That's a reasonable number. 10 units is a reasonable number. But a court might say, no, we think that a person looking on from the outside who wasn't associated with this transaction might think that 15 was a reasonable number of units. Now, I know that 10, 15 doesn't mean anything, but I'm just providing it as an example. So when we talk in terms of subjective, that's what you as the participant think is reasonable. That was your thinking, honest, and that's what you reasonably thought. But someone looking on might say, no way is that reasonable. It'd have to be 15 to be reasonable, not 10. So the question is, how do we determine what's reasonable in that context? Do we look at what the party thought, or do we look at what someone on the outside looking in might think as being reasonable? All right, thank you for that, Vicky. Clint wants to know, any Latin mumbo jumble in the test? Probably not. We try to avoid the Latin as much as we can, although I've got to say that in practicing in criminal law, sometimes the use of the Latin does make things which are really quite simple sound very complicated. and it does scare off lawyers that don't practice in criminal law from attempting to do it. I'll give you some examples. We might argue that a certain case should be the subject of a nolle prosequi because of blah, blah, blah. And lawyers that don't practice in criminal law say, oh, that sounds complicated. I don't think I know how to get a nolle prosequi. Well, I'll give you a little inside tip. A nolle prosequi is just simply a fancy term for saying the prosecutor offers no evidence and withdraws the matter. We say nolle prosequi. We could just say withdraw the matter, but if we say nolle prosequi, it sounds much more difficult. So there's some little examples, but no, Clint, there won't be too much of that Latin in the exam. All right. Now, legal research, we've also got, of course, our text, which is the Practical Guide to Legal Research. That's the 3rd edition. If you're using the 2nd edition, that's fine. There was some discussion about that on UCrew, I think today and yesterday. There might be some page numbers. The 3rd edition is more up to date. In terms of legal problem solving, we've already talked about IRAC. There is also the MIRAT method, which is very similar, and that is identify the material facts, that's the M in MIRAT. Identifying the issues, well, that's common to IRAC. Identifying and interpreting the rules, which is like IRAC. Applying the rules, that's like IRAC as well. And then applying the rules to the facts, arriving at a logical and supportable conclusion. So they're just different acronyms for effectively the same process. But I would like to just talk about that in a little bit more depth. And I told you tonight would be a fairly difficult and reasonably long session, so thank you for hanging in there. Let's talk about identifying the material facts. That may be difficult unless you know the law. We had that example of the supermarket issue. And so to some degree it's common sense, but sometimes you need to know the law a little to determine what's a material fact and what's not. So when you're doing your research, it may not be a linear process. And I suppose you can ask these questions are relevant when you're trying to work out what is a material fact. Ask yourself questions like who, what, where, and how. And that might give you a guide as to identifying the most material of the facts. Second one, the legal issues. We've talked about brainstorming. That's important. There's the basic distinction between criminal and civil. Identifying similarities between the problem and a legal rule, state law versus federal law, or both. Don't ignore the possibility that both may apply. The third part, which is the R, is interpreting the rules. Remember that we need to look at legislation. We also need to consider and look at case law, more than likely. The way I do it, I go to the primary source first, I go to legislation first. In the example I gave from the outset, ultimately I'd get to the Succession Act. Thank you again, Clint. And once I got to the particular section, almost always in OSLE, I'd always click on Note Up just to see if there's any cases that might have a quick bearing on the decision. If I'm completely satisfied that I have the answer based on my primary research, I probably won't go to the secondary resources, but I might, just to verify that the answer I think is correct. Other people go the other way. They go to the secondary resource first, the commentaries, and then maybe have a look at the legislation. I prefer to look at the legislation directly myself first up and go from there. All right, the fourth thing in MIRAT is applying the rules to the facts. Now, we remember legal reasoning. This comes into this. So there's reasoning by analogy, which is considering similarity. And that's where we look at precedents. So when we're applying the rules to the facts, we look at precedents, and that is essentially reasoning by analogy. That is similarity. We might consider inductive reasoning, which is where we broaden the horizons and we look at a specific principle to form a general conclusion. Thirdly, under the heading of applying the rules to the facts, we might look at deductive reasoning, which is where we narrow. That's the opposite to inductive reasoning, and that's where we take a general principle back towards a specific conclusion, as opposed to a specific principle to form a general conclusion. You've probably made a note of that. Hopefully that'll make some sense when you look at it again, but it's referred to, I think, in the text as well. And the final thing is just to arrive at a logical and supportable conclusion. Now, I've probably stressed this before, but you won't necessarily have any extra marks or have any marks deducted if you come to a conclusion which is different to the conclusion I come to or other lecturers down the track come to. The main thing is that you can identify the appropriate law and you can argue a line which is supportable and logical. It may be different conclusion to mine, but you might get 10 out of 10 even though you come to a different result. Think of it in these terms. If the law was so clear-cut that everyone could identify the law like solving a maths equation, we wouldn't need cases, we wouldn't need judges, everyone would know the law and say, that's it. Think about the High Court. The reason that we have a bank of High Court judges, like 7, is that it's assumed that not all High Court judges will come to the same conclusion. And it may well be that on a constitutional or other matter, we have 4 judges go one way, 3 go the other. It is totally inappropriate to say that the 3 who came to the minority decision must be completely wrong. Their arguments might be completely logical, completely supportable. It's just that they were different conclusions to the other 4. So don't get too hung up on having the right answer. Think about the process and being able to support your conclusions. All right. Now, so number 1, this is my notes clearly that I'm referring to. I made notes about legal problem solving. That's the Myrat method. I've concluded that. Well, the first part, sorry, is the method. Second thing is clarifying the legal issues. I just want to talk about that. The example which is used in the Practical Guide to Legal Research is the family law issue involving child abduction. The way in which the author says you should go about your legal research is start general and then become more specific. So that's brainstorming and then become more specific. Using a legal dictionary. I confess I don't use that a lot, but I think it's a good idea. Using legal encyclopedias, that's Halsbury's in LexisNexis or Laws of Australia and Thomson Reuters. I think that's a great idea, and that's a really good way to use a secondary resource. And maybe group your ideas and terms using Boolean connectors. And there's a reference table in your text which shows you how to use the words and or not in that context. All right, so effective research, work quickly but thoroughly, think laterally, use double quotation marks around terms so as to obtain a phrase, and consider online legal researchers such as Ostly. We've talked about that, the note-up function, and other ways of dealing with it. All right. We've talked about brainstorming tonight. I think we're probably getting pretty close to the end of what I'd like to talk about tonight. It's been a fairly long session already. There's more that I want to talk about next week by way of catching up, and that's primarily to do with resilience. I really haven't covered, as well as I'd like, Chapter 10 of The New Lawyer. So I propose to deal with that next week. I'll have to make it myself a reminder to do that and just talk about the issue of resilience. As I mentioned, that type of thing is examinable. Unless anyone has any objections, that's probably where I should leave it tonight. But before I do, quick roundup. Are there any questions? Anything you want to ask live? Any questions that you want to ask through the chat facility? Vicky says, may I ask how to best prep for the exam? Understand that you've given us some things to consider for the exam. Yep, so I've given you some general ideas. I think if it were me setting this exam, I would take a punt on a few of the areas and I'd actually prepare my answer pretty closely. That's going to take a lot of stress out of the exam, because I don't care if you walk in with your own pre-prepared answer dealing with separation of powers. In fact, I would say you should really do that. I know you have to rewrite it, and that's a bit tedious, but think how much fun that would be if you happen to score almost exactly the right question and you'd prepared thoroughly for it. Glue, no, glue you can't use, Peter, but nice try. That won't work. Now, a bit tedious to handwrite. Well, just think back to when I was doing law back in, I think it was about the 18th century. We had no computers and we had one exam for the whole year and we had no open books. So I had to memorize everything, and then you're just writing like crazy for 3.5 hours. I think your exam is about 3 hours. Does anyone know how long the intro exam is? Someone says, I apologise for my handwriting. Don't worry, I'm pretty good at deciphering handwriting. 3 hours, says Peter. I think it is. All right, so you've got plenty of time, but what that means is that if you've got plenty of time and you've got open book and you've been given some hints, well, guess what? The trade-off is that I expect a pretty high standard. So please, yes, Maria, yeah, pretty high standard. So please be willing to put in the effort before you get to the exam. Don't think about the issue of separation of powers. At the exam, you should be well and truly prepared. Have your notes, have your thoughts collected. So I hope that answers your question, Vicky, in terms of providing some guidance as to how to prepare. All right, are there any other questions or comments before I wrap up for tonight? And I do thank you for your patience. All right, you're welcome to stay online for a chat after the recorded session, but I'll end the recorded session now, and I thank you for listening. All right, are there any questions before we wrap up? Okay, thanks very much, and we look forward to chatting to you next week and through Review Crew. All the best. Bye.
Yeah, John.
Bye.